We consider this an important report, and I want to emphasize something that's really practical in terms of the work that we do on the ground. So having said that, laws and policies are, of course, not the end of the story. It is very much their implementation that is key. And that's why this year's report has included an important element of the implementation of the IDP laws and policy. And in fact, the discussion today will focus primarily on that. And we're lucky to have with us today a number of experts on the topic. And I will introduce them as we come to the panel and to the presentation of the report. But I'd like to start off by welcoming the Special Rapporteur on the Human Rights of IDPs, Ms. Paula Gaviria. And please, I would like to give you the floor to start by framing today's event. Over to you, Paula.
Thank you very much, Elizabeth, and hello to everyone. Over the past 5 past years, we have witnessed a significant increase in political momentum around the protection and the solutions for internally displaced persons. This momentum was sparked in 2019 by the UN Secretary General's High-Level Panel on Internal Displacement, followed by the issuance of the UN Secretary General's Action Agenda on Internal Displacement. Implementation of the Action Agenda was in full swing for the past 2 years under the leadership of the UN Special Advisor on Solutions to Internal Displacement. More than ever, as responses are expected to turn towards life-saving assistance and away from long-term and integrated responses, it is crucial that we sustain this momentum. We must increase efforts that have a positive impact on displaced people's lives. This report, being launched today, is a vital tool in that effort. I am honored to have written the foreword and to provide opening remarks today. UNHCR's capacity and support on law and policy on internal displacement are highly valuable. Through co-convening government exchanges with UNHCR under the IDP Protection Expert Group, I have seen UNHCR's expertise on law and policy in action. I have no doubt that UNHCR and all its partners have played a role in the increase in the number of laws and policies on internal displacement we have seen over the past 2 decades, which deserves recognition today. But now, law and policies are important and fundamental to state responses to internal displacement and IDP protection. They provide the necessary framework, as Elizabeth said, to ensure the responses are structured, are consistent, are rights-based, and are aligned with international standards. National laws and policies on internal displacement are essential to preventing arbitrary displacement, protecting the human rights of internally displaced persons, and enabling durable solutions for their displacement. National responsibility remains paramount, and especially in the current context, where we see constant and increasing violations of international humanitarian law. States have the primary duty to protect and assist IDPs within their borders, ensuring their rights or well-being. We are here to support states in fulfilling their obligations. As the UN Special Rapporteur on the Human Rights of Internally Displaced Persons and former government focal point responsible for law and policy implementation, I have seen firsthand that there is no substitute for having adequate laws and policies that protect the rights of the IDPs. I have also seen how implementation of laws and policies on internal displacement is an organic process that demands flexibility and, I would say, patience. To give one concrete example, in Colombia, the 2011 Victims Law created a reparations regime for IDPs and other victims. The 10 original years had to be extended 10 more on account of continued displacement and the slow and complex process. History has shown that laws and policies are only as effective as their implementation. This report, through its meta-analysis, serves as a practical manual for policymakers on the elements of protective laws and policies on internal displacement. One takeaway from the meta-analysis is that an effective IDP response will require a combination of legal, policy, and operational interventions that are both IDP specific, addressing their displacement-related needs, and IDP inclusive, supporting the inclusion of IDPs as citizens and residents into national systems. The meta-analysis found that complementarity non-IDP specific instruments like socioeconomic areas are likely to be of equal or greater importance in protecting people from displacement and addressing its key drivers. In other words, interventions to respond to internal displacement should both target IDPs specifically and include them in broader programs and systems. This serves as well to establish conditions for durable solutions and prevent displacement by facilitating pathways towards inclusive development through settlement-based interventions where IDPs and displacement-affected communities benefit as citizens and residents. Despite the progress made, much remains to be done to address the global crisis of internal displacement. I call today on governments to act with the highest commitment to protection of internally displaced persons and to invest in resilience and solutions. Otherwise, in the current context of scarce resources and prioritizations of life-saving assistance exclusively, we risk reversing all that has been achieved, and even worse, rendering IDPs more vulnerable and halting their progress on solutions pathways. As highlighted in the report, the sustainability of interventions by governments and partners is key. We must be innovative and collaborate through advocacy, technical assistance, knowledge sharing to accelerate and expand efforts and sustain them where needed. I welcome this report as an important instrument for policymakers and practitioners on the road ahead to fulfill the promise of national responsibility and safeguard the rights of internally displaced persons worldwide. Thank you.
Thank you very much, Paula. I'd like to now call upon UNHCR's Assistant High Commissioner for Protection, Ms. Ruvendrini Menikdiwela. Over to you, Ruven.
Thank you, Elizabeth. And I'd really like to join you in thanking this. I see now 163 participants who seem to be who have joined this launch, and I think that's really a measure of how important this issue is. I just want to, Paula has underlined the importance of legislative and regulatory frameworks for the protection of IDPs, and also how critically important it is that these frameworks be implemented if they are to actually be given any kind of agency. And I am so glad that this second global report actually does focus exactly on that, on the implementation of these laws and policies. And I think that's really something critical that we need to absolutely focus on in the years going forward as well. I also know, though, that it is impossible sometimes, well, difficult and sometimes even impossible to assess the impact of laws and policies on IDPs, very much like in other areas of the humanitarian domain as well. The absence of such laws and policies are felt far more acutely sometimes than their existence. And I think that is proof positive of how absolutely necessary they are. And I just want to say, what does the lack of policies and laws imply? It implies that IDPs are deprioritized or not given any kind of priority, that there's no national strategy in relation to the protection and assistance of IDPs, that there are critical gaps, sometimes even life-threatening gaps in protection and assistance, and that basically when there is protection and assistance, sometimes that there's actually massive duplication as well, with international actors coming in to try and offset the lack of national protection. And these are all critical areas that can only be effectively addressed if you actually do have effective laws and policies on the books, which are equally effectively being implemented. Why is this of huge interest to UNHCR? Not simply as an institution, because of course we are interested in the protection of IDPs, and as the lead of the Global Protection Cluster, this is an institutional responsibility that's even more magnified. But it is quite simply that today's IDPs are well going to be tomorrow's refugees if they're unable to avail themselves of the national protection and access to services that in their own countries of origin. And I will come back to that a little bit further down in my comments as well. What is important in this paper is that basically it does show that proper implementation of laws and policies can craft consensus on who is an IDP, who is responsible for what, and how and what member states will pay. And these are, I think, the fundamental elements in upholding the rights of IDPs. I mean, no country wants a perpetual IDP situation, even if they ignore it for the longest time possible. The presence of IDPs is always going to be an insurmountable obstacle to peace and to development. And that is something that all national governments across the board are going to be interested in. So solutions are a must. And this is why it's also critically important that these laws and regulations exist and that they're properly implemented. But one of the challenges of today's world, and Paula alluded to this as well, is the financial crisis that we're going through, particularly in the humanitarian domain. I just came out of a meeting on a member states briefing on the Global Compact on Refugees, and the dominant issue, as you can imagine, particularly from host governments, countries that have been hosting refugees, vast numbers of refugees for protracted periods of time, is who is going to pay? We are in an environment of unprecedented challenges when it comes to humanitarian funding. And this is even more acutely felt for the IDPs, because at the end of the day, IDPs are still nationals remaining in their own countries, which means that their governments have to be absolutely vital, play a vital role, and have to absolutely take the lead in protecting and assisting its own citizens. And this is why I think our collaboration, certainly with the Special Representative's Office and her team, is so important and so precious to all of us. A couple of bits of pieces of data that I would just like to dwell on as well, on a more positive note. As of December last year, there were 49 national laws on IDPs adopted in 18 member states, and that's huge by any reckoning. And I most recently in Honduras, in the Republic of Congo, and in Chad. And I just want to dwell on the Honduras for a minute, because I was there last year and I met with a group of IDP women. These were women who had been internally displaced within their own country several times, to the point where they finally decided to up sticks and leave, and to make that incredibly hazardous and dangerous journey towards the Darien Gap and then towards the southern border of the United States. They did not succeed. They came back having endured some of the worst, most heinous, and unimaginably degrading treatment that you can imagine. They came back, though, determined to do two things. One is not to leave again. Even though they did come back again to situations of internal displacement, they were determined that they were going to remain where they were, and they were equally determined to ensure that their government was called to book on creating an effective protection and assistance landscape for IDPs in Honduras. And they were equally determined, as several of the women told me, we don't want any other woman to go through what we went through. The fact that we had to move from place to place in our own country, that finally we had to abandon everything that we held dear to leave our country and try and seek asylum elsewhere, and that we were unable to succeed in that, even having gone through some of the most traumatic experiences, that we were forced to come back to Honduras, again to a situation of internal displacement. We don't want that happening to any other woman. We want to make sure that we establish, that our government establishes laws and policies that are properly implemented and protect the people that it's designed to protect. And I think that is one of the critical things, one of the major takeaways for me from that mission, was essentially the determination of these people to ensure that their governments were called to book, that their governments protected them the way they have every right to be protected as nationals in their own countries. And again, it showed that inextricable link between refugee movements and the situation of the internally displaced in their own countries. I think one of the other things I do want to say is the importance of regulations to implement these legislations. And that's obviously, again, something that's coming up in Chad and Honduras as well. And again, these women were saying the same thing. They said, it's great, we have achieved something, we lobbied the government, we've got this law on the books, but now we need to make sure that it is properly implemented. That was their second priority, and that's what they were focusing all their energies on. And having met that group of women, I have no doubt at all that they will succeed in their objective, and we definitely need more groups like that. I think that's the second message that I took away from that. It's the importance of that critical bottom-up or grassroots approach. And it's interesting that almost half of the existing legal frameworks are at a subnational level, according to the report. And the Philippines is a classic example of that the Philippines adopted a regional law on IDPs through the ordinance of 16 municipal ordinances. And I think that's, again, hugely illustrative of the fact that grassroots movements the local communities, the local governments have a key role to play in the protection of assistance to IDPs. In Niger, the legislation is already having an impact, not least through UNHCR's efforts and other actors as well, in capacitating and raising awareness of the defense and security forces, which, as you know, play a key role in current-day Niger. The fact that we trained these security forces and these defense forces actually effectively prevented the forced relocation of groups of IDPs. We are not always successful across the board, but sometimes we do have an impact, and it's critical to document that, because that is really a precedent that needs to be adopted in other countries as well, and certainly one of the examples of how we should be moving forward on this. I also know that UNHCR is currently supporting the development of about 20 national and subnational frameworks, for example, in Ethiopia, Nigeria, and the Mexican state of Oaxaca. I'm sorry, deepest apologies for having massacred that name, the Mexican state of Oaxaca. And again, we are hoping that in the next instance of reporting on these legislative developments, that we will be able to say that these 20 national and subnational frameworks have been effectively adopted. It's also true that many member states prefer to go down the route of adopting policies rather than adopting legislations, because sometimes the legislative processes can be hugely cumbersome, time-consuming, and may not achieve the objectives that they were designed to do. So policies are fine, and we have some 97 policies in 40 member states that have, in all continents, that are documented in this report as well. And what is also encouraging is that almost all of these policies are dedicated to sustainable solutions for IDPs. And again, I do want to underline that link between solutions for IDPs and solutions for refugees, because where solutions are found for IDPs, it's almost inevitable that nationals of that country who have sought asylum elsewhere are going to be encouraged to return back voluntarily because of the fact that solutions are found. So solutions for IDPs go hand in hand with solutions for refugees as well. And again, something that shows the criticality of the link between the mandates that UNHCR carries, both in regard to refugees and in regard to IDPs. The other final, and I just really like to leave you with this message. I know you're not here to listen to me. You're really here to listen to the far more knowledgeable and incredibly impressive lineup of experts who are scheduled to speak. But I do want to leave you with one last message, and that is essentially there are a lot of questions being asked about the political and financial climate that we're currently in, and the fact that UNHCR does have a primary mandate for refugee protection. And that is a question that comes to me quite frequently, saying, does that mean that you are now going to be placing a secondary focus on IDPs? Because of course, in this incredibly financially constrained environment, you are going to be putting your priority on refugee protection. I do want to reassure all of you who are participating in this launch that no, we will continue to give equal priority to the protection of IDPs, because again, as I said, today's IDPs could well be tomorrow's refugees. We have every interest in stabilizing populations in their countries of origin. We have every interest in ensuring that people have the right to remain in their countries of origin, that they're not compelled to flee. That is part of our critical refugee mandate responsibilities as well, to create conditions in the countries of origin that are conducive to the return of refugees, but are also conducive to people remaining in place, the prevention of refugee movements. So for us, these activities that we're doing under the IDP umbrella continue to be critical, continue to be given a priority, regardless of the environment that we're currently operating in. And I just want to ensure that you do understand that, and that we will continue to ensure the meaningful consultations with IDPs on laws and policies and solutions that involve them, that we will continue to capacitate government bodies and to assist and to provide technical assistance to governments in relation to the protection and assistance of IDPs. Because as one of my colleagues put it, if we don't do it, nobody else will. So I'll leave you with that. Thank you, Elizabeth.
Thank you, Ruven and Paula, for framing this report. And so it's time to delve into the report a bit. And I'm very happy to hand the floor to David Cantor, who is the director of the Refugee Law Initiative at the University of London. David, over to you.
Well, a very good afternoon, everyone, and many thanks indeed for the invitation. I'm pleased to join you today from the Internal Displacement Research Programme, a specialist programme at the Refugee Law Initiative here at the University of London. It's a really great privilege and pleasure, as always, to share the platform with UNHCR and collaborate both in this event and, of course, also in the writing of parts of the report. So the new UNHCR Global Report, alongside the various developments described just now by Ruven, also incorporates a series of reflections on how existing national law and policy on internal displacement is implemented. And this very much builds on the earlier section of this report and also the 2022 version of the Global Report, which, when taken together, provide a comprehensive baseline of states' efforts in developing national law and policy on IDPs. The study in this second section of the new report aims to take a further step in building our understanding of how law and policy in this area contributes to the development of effective responses at the national level. Clearly, the adoption of domestic IDP laws and policies plays an important role in ensuring an effective response to situations of internal displacement. And it's also fundamental to states taking ownership of the issue in their own countries. But the creation of national laws and policies does not tell the full story of how or whether states are taking ownership of this issue in practice. For this reason, there's a need to better understand two things. Firstly, how national laws and policies frame the response to internal displacement. And secondly, how the institutional structures set up to implement these standards are arranged and function in these contexts. So with those objectives in mind, the study in this year's Global Report presents a series of new findings that highlight common challenges, good practices, and lessons learnt. Moreover, running throughout the analysis, the study addresses important underlying questions about the role that national law and policy play in shaping implementation of the IDP response, and also the factors affecting the institutional implementation of that response in practice. Next slide, please. This study was produced through a short period of desk-based research by myself and Martina Katarina of UNHCR. And we'd like to thank all of those UNHCR colleagues, government officials, and others who provided input on the implementation of IDP laws and policies. This was really very useful, especially given the relative paucity of published data on these issues. The study focuses on how selected countries address displacement due, in particular, to conflict and violence, amongst other drivers of displacement. And on this topic, we selected 15 countries that are home to significant and unresolved dynamics of violence-driven internal displacement. This selection sought to capture a number of important variables, as you can see on the screen. A research challenge in this process, but also an important finding, is the fact that both conflict and displacement patterns and trends are dynamic, and the responses of governments likewise change through time. So against this backdrop, the study focuses very much on three main areas of the IDP response. Firstly, its personal scope. How do countries define the scope of internal displacement as the problem to be addressed by their IDP response? Secondly, its material scope. In other words, how do countries frame the standards governing implementation of that response in relation to prevention, protection and assistance, and solutions? And then thirdly, the government structures themselves. So how have countries designed and utilised institutional arrangements to respond to this kind of displacement? So if I could have the next slide, please. So among the many findings and recommendations produced by this short study, I'd like to highlight 5 areas that you can see at the moment on the screen. So firstly, talking about the frameworks. Well, in most of the 15 countries, the IDP response is based primarily on interventions that are specific to IDPs. We found that these, if you like, IDP-specific frameworks provide a crucial point of reference for establishing a holistic and comprehensive effort across government. Such IDP frameworks set out particular needs and standards for the IDP response, and institutionally they clarify roles and responsibilities. Clearly, wherever possible, they should build on existing apparatus of government rather than creating a new system or different administrative approach specific to IDPs. However, these IDP-specific frameworks need not take the form of a law, as Ruven mentioned. A policy may suffice, if that's all that's needed to spell out how existing domestic legal or constitutional rights for citizens apply in relation to internal displacement. Even so, in some countries, a law may be required. For example, where the activities involved in IDP response require specific legal authority. We're talking about things like budget allocations or attributing new institutional responsibilities and so on. So at a minimum, IDP instruments, we thought, should do three things: address current displacement issues, be flexible enough to handle changes in the situation to the extent possible, and of course, lay a solid foundation for achieving sustainable solutions. Within all of this, the guiding principles still represent a fundamental starting point for identifying needs and creating such responses. Another clear finding from the study on frameworks is that the implementation of an effective IDP response will require a combination of legal, policy, and operational interventions, and they will often include not only these kinds of IDP-specific interventions, i.e. those that specifically target IDPs to address their displacement-related needs, but also IDP-inclusive interventions, those that support the inclusion of IDPs as citizens and residents in broader national systems. The country case studies in the report suggest that inclusion of the IDP issue in these wider national frameworks is essential, not only for promoting a whole-of-government approach, but also for supporting IDPs' sustainable economic and social reintegration into mainstream society and ensuring respect for IDPs' rights as citizens or habitual residents of the country. Moreover, it's clear that IDP-specific interventions are usually particularly necessary at the point in time when displacement-specific needs are greatest, usually fairly soon after displacement. By contrast, as these needs ideally decrease over time and IDPs make progress towards durable solutions, IDP-inclusive interventions become increasingly vital to reinforce or complement IDP-specific ones. Finally, especially in protracted situations, we identified a risk that internal displacement can become treated as an institutionalized problem, and this makes it much more difficult for a society to overcome. But a robust response can be implemented without becoming intractable, and it can be done by ensuring that targeted and perhaps time-limited context-sensitive policies, strategies, or plans are used to implement the core framework, that institutions are allocated clear roles and responsibilities, that solutions are built into the response from early on, that regular reviews based on adequate data and analysis are able to assess progress towards solutions, and that IDP-specific interventions transition as quickly as possible to IDP-inclusive interventions. In short, on frameworks, no country wants a perpetual IDP crisis, and using IDP frameworks to chart a path to a way out of the crisis is absolutely essential. Moving to the second point on IDP definitions, a few national IDP laws and policies, talk here about Niger, Nigeria, Yemen, exactly mirror the, if you like, international descriptive definition of IDPs found in the guiding principles. But many countries in the study have changed elements of this definition to contextualize it in relation to the situations of internal displacement in each particular country. The IDP definition in the guiding principles can be legitimately tailored to local circumstances by the IDP framework at the national level. And this is often a useful or necessary step for clarifying or targeting the scope of the IDP response in that country. Indeed, no one size fits all. At the same time, though, states should be aware of possible consequences, such as the risk of inconsistent definitions in a single country, as we see in some studies, or those which exclude certain groups of IDPs in a discriminatory way. On definitions, we also found that states take different status-based and other approaches to how they operationalize the IDP definition as a way of targeting the IDP response. Now, each of these different administrative approaches to operationalizing the definition has particular substantive and procedural consequences for how the IDP response is structured. For example, a status-based approach provides IDPs who fulfill certain definitional requirements with specific benefits and rights as IDPs under national law. But a state creating a new IDP legal status will need to address important questions that can't easily be resolved by recourse to international frameworks on IDPs. Questions like what exclusion criteria should there be? Should the status pass to children? And it also risks siloing the IDP issue and potentially creating dependency. But these different status-based and other approaches are not necessarily mutually exclusive, and two or more could be applied in tandem. For instance, even countries that have adopted an IDP status, or which provide certain entitlements to all registered IDP populations, see as appropriate some level of policy or practical prioritization in the provision of IDP-specific assistance, and this is often based on a nuanced analysis of specific IDP needs and vulnerabilities. Ultimately then, what's crucial is that the approaches taken in any single country are context-sensitive and appropriate to its wider administrative approach to similar social and policy issues, as well as to the scale and nature of the particular displacement situation. Coming on to the third topic of IDP-specific standards, the study illustrates the point that a national framework setting out the basic scope and standards for the IDP response really is essential for principled and coherent implementation of that response. And this plays out across the stages of prevention of arbitrary displacement, protection assistance of IDPs, as well as solutions to internal displacement. Now, on the first of these stages, many core IDP frameworks in the countries sampled affirm the principle of preventing displacement in line with international standards. This is articulated primarily as a prohibition of arbitrary displacement, although there's some variation as to its scope between countries. However, complementary non-IDP specific instruments, in other words, those on security or socioeconomic issues, are likely to be of equal or greater importance in protecting people from displacement and in addressing root causes and key drivers. By contrast, we found that most of the countries show a considerable degree of consensus on basic IDP assistance and protection standards. More interestingly, though, in most national IDP laws and policies, the rights sectors for assistance and protection, could think here about WASH or safety or other areas, are substantially similar to those for achieving solutions for IDPs. And crucially, this suggests that the standards underpinning protection and assistance on the one hand and solutions on the other are less distinct than sometimes assumed. It also points to a strong legal or policy basis for complementarity between short-term humanitarian interventions oriented more towards assistance and protection and longer-term development interventions oriented towards solutions and inclusion. All of the 15 countries sampled, even those lacking core instruments on other stages, have adopted national instruments concerned with the solutions stage. And often they identify strategic and pragmatic actions needed to move towards durable solutions within a particular time frame. However, rounding out the section on standards, it should be noted that a political focus on IDP returns as the only or favoured solution does remain explicit in some domestic frameworks in these countries. On the fourth point of institutions, we found that a core national framework on internal displacement is needed to effectively identify and task the institutional structures through which the IDP response is to be implemented. Indeed, it's not possible for a government really to mount a consistent response at scale without legal or policy instruments setting out roles and responsibilities of state institutions in relation to this undertaking. Clearly, their specific form will depend intrinsically on the wider governmental setup of the particular country in which they're located. Nonetheless, from the study, it's clear that one and only one focal point institution should be clearly identified to lead that national IDP response. This focal point needs sufficient institutional ranking and ability to carry this agenda across government and will benefit from direct reporting to the highest political levels. That is because an effective IDP response seems to rest on a shared whole of government approach. Core IDP instruments also play a useful role in setting out the respective responsibilities, not only of the focal point, but also national ministries and agencies and subnational territorial entities, as well as in usefully establishing the national platforms for horizontal and vertical coordination led by the focal point. The study also, on the institutionality aspect, identifies important examples of how national IDP frameworks can include provisions on internal displacement data, providing clarity on the purposes for which data will be gathered and the systems for collecting, analysing, storing and sharing data. IDP-specific interventions, we found, also tend to require dedicated funding streams or sources, and in practice, this is an issue. Domestic budgeting for the IDP response tends to be quite opaque in many of these countries. However, this is an issue that can usefully be identified in national IDP frameworks, and it was seen in some cases, and indeed, IDP-inclusive interventions can also aim to draw on wider funding streams. Coming to this last theme about capacity and willingness of institutions, within the study, we found that prioritisation emerges as a key strategy for addressing limited financial capacity, and clearly, given developments of the past few months, that's going to be even more crucial. In implementing the standards of the core IDP instruments, prioritisation can privilege the needs of the most vulnerable IDPs or the territories most affected by internal displacement. Sensitivity to context is crucial here, and the general application of such measures should be principled and based on the best available data and analysis of that situation, and of course the implications for beneficiaries and the wider IDP population too. It'll come as no surprise that we found that international entities have often supplemented the shortcomings in state capacity, and indeed the relative scale of international engagement on IDP issues in some of the countries was such that they're effectively a key driver of the IDP response. Indeed, in some countries, the effectiveness of the state response to internal displacement is quite difficult to disentangle from questions about how the international community engages with and indeed supports institutions of the state. Moving on from capacity to the issue of political will, the study shows that a high level of willingness to both adopt and implement domestic IDP frameworks can be seen, particularly in countries where the IDP response resonates with government, not only for humanitarian reasons, but also on other political grounds too. More generally, a sense of national ownership can be built up, for example, by engaging relevant institutional actors in the process through which IDP frameworks are developed and adopted. For sustained implementation, though, the key is to insulate such institutional buy-in from changes of government. And this can be done through careful selection of key interlocutors in the state, such as national human rights institutions. But other domestic actors can be really vital too. In some countries, as I think we're about to hear, the courts may have the potential to enforce state willingness to implement IDP frameworks through changes of government and so on. Likewise, engagement by international partners and civil society, including by IDPs, can reinforce institutional willingness and capacity to implement IDP frameworks. As a final point on capacity and willingness, across the study, we found that middle-income countries with relatively strong and functioning state institutions and legal traditions, unsurprisingly, generally assumed greater ownership of the IDP issue. Willingness and capacity to implement IDP frameworks thus seems to relate closely to such structural features of the country context. As such, national IDP frameworks should build on the particular institutional strengths of those countries in developing an IDP response. But conversely, wider structural limits to the functioning of institutions in a country also need to be taken into account, particularly in low-income countries with fragile institutions and a weak rule of law, where state capacity for IDP response tends to be modest. So I hope this brief overview gives a flavour of some of the key findings from the report, and I very much look forward to hearing the comments from our panel of expert speakers and during the question and answer. Thank you very much.
Thank you very much, David, for that overview. I think that's extremely helpful for the next part of our program, which is that we have a panel of 3 experts joining us, and I'm going to ask each of them a question to help us to unpack a bit more how the report can help us in practice. So I would like to start off by introducing, first of all, Ms. Olga Mykolaivna Altunina, who is a representative of the rights of citizens affected by armed aggression against Ukraine of the Ukrainian Parliament Commissioner for Human Rights. So if I could ask you, please, Olga, how can the law, policy, and institutional frameworks of a country support effective and meaningful engagement by civil society and IDPs themselves in the IDP response? And could you offer some reflections from the experience of Ukraine on what has worked well and some of the challenges that might be there in practice? Over to you, please.
Дуже
Dear
дякую,
colleagues,
що дали
hello.
можливість розповісти
I'm
і
very
про досвід
grateful
України, і поділитися рефлексією щодо
having the
глобального
word at
звіту.
this
Я сподіваюся, мене чутно,
conference
переклад
and
працює.
providing my reflection on this global report. Do you hear me? Is there interpretation?
Добре. Тоді почну з того, що
Okay.
щодо
So let
вашого
me
питання
start
про які
from your
законодавства,
question
як законодавство або які
on
політики могли
in
б
what way
сприяти
policies and legislation can support
ефективному залученню
the
громадянського
effective
суспільства. Скажу,
engagement
що
of
в
the
Україні після
CSO.
повномасштабного
Let me
вторгнення
tell you that after
держава
the
здійснювала
in
ряд
full-scale
заходів,
invasion
які були
against
направлені
Ukraine,
на
the
покращення
state
умов
was able to
ВПО.
implement a
Однак
number of
громадянське
activities
суспільство
to
дуже класно
improve the
спрацювало.
conditions of the
І ми
IDPs,
побачили, що
and the
без підтримки
CSO
громадянського
helped us a
суспільства державі
lot.
дуже
We
складно
could see that
впоратися одразу
without
на
the
двох
support
фронтах, на
of the civil
військовому і
society,
на
the state could
фронті
not
підтримки
deal
внутрішньопереміщених
both with
осіб.
the front
Тому
line
сьогодні,
and with the
мені здається, важливо не тільки
support
для
of the
України, а для
IDPs.
будь-якої країни, в
So I think
якої є
that
проблема
both Ukraine and any
внутрішнього
other
переміщення,
country where
це
there is a
закріплення
problem
на
with the
законодавчому
internal
рівні,
displacement,
тобто
it is
випрацювання
important
якихось правових
to
рамок або
adopt
норм для участі
the
громадських
relevant
організацій щодо
legislation
допомоги і підтримки
for the
внутрішньопереміщених
NGOs
осіб.
to support
А також
IDPs.
створення громадського контролю
And it is important
за
to
використанням
develop
бюджетних
the
коштів,
civil
які
control
виділяються
over
або на
budget
центральному, або на
allocations,
регіональному, або на локальному рівні
either on the
щодо
national
підтримки
or the
ВПО.
local level, as for
Також
support
було
of the
би
IDPs.
правильним
Also, it would be
запровадити
quite
утворення
important to
консультативно-дорадчих
introduce
органів при будь-яких органів
consultative
державної виконавчої влади або
institutions,
при органах місцевого самоврядування,
councils that would
які
support
би
all kinds of
транслювали і
institutions,
показували
either
основні
national
потреби
or
ВПО,
local
бо не
level,
завжди органи
that
місцевого
would present
самоврядування
the current issues
готові
of
або
IDPs,
можуть
because quite
бачити
often
проблематику.
local administrations
Це про
cannot
той
see
девіз, знаєте, що не
the whole
треба для
scope of
нас
issues
без
that
нас.
IDPs have.
Тому голос
It's
ВПО
important to
має бути
remember
почутий, але
that
почутий
the
він має
voice of
бути
IDPs should be
через
heard.
організації, які профільно займаються
Their voice
ВПО.
should be heard
Мені здається, що
through
це було б дуже
the
класним
profile specific organizations
кроком.
that deal with IDPs.
Щодо
That would be a great
політик або
step.
стратегії. Зрозуміло,
Speaking
що
about
будь-які
policies and
кроки
strategies,
держави будуть хаотичні,
let
якщо
me
не
note
буде
that any
випрацьована
steps
державна
of the state would
стратегія
be
щодо підтримки і
chaotic
захисту прав ВПО.
if there is no
І такі
national strategy
стратегії,
for
така
IDP
стратегія,
support
наприклад, в
and
Україні
such
була прийнята,
strategy.
але вона
In
показала,
Ukraine,
що якщо
it
немає
was adopted
індикаторів,
in Ukraine,
якщо немає
but we
системного
could see
звітування,
that without
такі
indicators, without
стратегії
reporting,
залишаються лише паперовим
such
документом.
strategy is just something
Тому
written on the
будь-яка
paper,
стратегія,
nothing
по-перше, вона
more.
має бути в принципі.
So any
По-друге, вона
strategy,
має передбачати
first of all, it
чіткі
should be developed, but secondly,
часові рамки,
it
завдання
should have
чіткі виконавці і
some
головні
clear
індикатори
indicators,
для того, щоб
tasks,
і суспільство,
and
і ВПО, і держава розуміла, чи
terms,
вдається реалізовувати,
because
власне, цю
both
стратегію.
IDPs and the state should
Що
understand whether
стосується написання
strategy is
самої
implemented.
стратегії, то
Speaking
однозначно
about
до її
drafting the
написання
strategy,
має бути
it is
залучена спільнота
important
ВПО,
that
а також
the
профільні громадські
IDP
організації, які
community should
розуміються
be
на цій
part
тематиці.
of the
Тільки в
drafting,
такому
as well
випадку
as
ця стратегія
CSOs
буде
that understand how it
врівноважена
works.
між інтересами
Only in
держави
this
і
case, the
фінансовими
strategy would
спроможностями
be
і
somewhere in the
потребами
middle between
ВПО.
the state capacities
Також
and
політики
IDPs'
мають
needs.
включати не
Besides, the
тільки
politicians
декларативні
should include
заходи,
not
а
only
мають включати
declarative
реальні
measures,
кроки
but
фінансової
also
підтримки. Це
some real
може бути не
actions
обов'язково
of financial support,
гуманітарна,
not only
продовольча або санітарна
humanitarian or
підтримка.
food
Це може бути
or
підтримка
wash support.
психологічна,
It
це
can be
підтримка
psychological
щодо
support. It can
людей
be
з інвалідністю, це
support for
формування
people with
державної політики щодо
disabilities.
забезпечення житла.
It can be drafting
Ну і
state
звичайно, що
housing
будь-яка
policy.
стратегія або будь-який план
Besides,
держави
any
не
kind
може
of
бути реалізований
strategy,
без
any
створення спеціалізованих
state
органів.
agenda plan cannot be drafted without
Наприклад, в Україні було
specialized
створене Міністерство
bodies,
реінтеграції, яке
authorities.
профільно
For example, the
займалося
Ministry for
внутрішньо
Integration
переміщеними особами.
was operating in Ukraine.
Але на
It
центральному рівні ми
was
побачили, що на центральному
professionally
рівні
working
цього
with the
недостатньо,
IDPs, but
що
you could
такі
see that it
профільні
wasn't enough at the
підрозділи
national
мають бути в
level.
кожному регіоні.
Such
Тільки тоді послуга
profile
дійде якісна
administrations
до
should be
кожного
present in
ВПО.
every
І
region
потреби
for us to provide
кожного ВПО будуть
quality
почуті.
services for each IDP
І всі
and to
дії
hear
державних
each
органів
IDP.
і органів
So
місцевого
all
самоврядування
activities
мають
of the
бути
state
прозорі,
authorities and
чіткі
the
і
local
відкриті.
bodies
На їх
should be
публічних порталах має
transparent
бути
and
повністю відкрита
effective.
вся
They should
інформація
have
простою
web
зрозумілою
portals,
мовою, для того, щоб
and
ВПО незалежно
such
від
portals
віку,
should include
статі,
information in the
освіти,
most
могло
simple language
зрозуміти,
for any
що
IDP,
держава може надати.
regardless of their
Ну і
education
в Україні
and
дуже
social
гарно
status, to
показала практика
understand
створення
what's going
ресурсних
on, what
центрів
can be
для
provided by the state.
ВПО, де вони можуть
Besides, we
отримати
had great practice of resource centers for the
або
IDPs,
будь-яку іншу допомогу.
where they can
Що стосується взагалі
have
досвіду позитивного і
consultative
негативного в
or
Україні, хочу сказати, що почати
any
з
kind of
цифр.
other assistance.
Сьогодні в
Speaking
Україні
about
4 мільйони
experience in Ukraine,
627
let me
тисяч
start with
ВПО.
the figures. Today we have
Це дуже
like
велика цифра.
4.6 million of
З них
IDPs in Ukraine.
200
It's a huge
тисяч
number.
людей з інвалідністю.
200
Мільйон
of
300
them,
пенсіонерів.
200,000 of them are people with disabilities.
880
1
тисяч
million
дітей. І на цю
300,000
велику цифру внутрішньо переміщених
are
осіб
retired. Many
створено
of
всього
them are many people are
74
children, in
тисячі
fact,
місць в
but in
колективних
fact we have
центрах,
only
місцях тимчасового розселення.
74,000 beds in collective centers for
3,4
all those
мільйони
people.
українців залишились без
3.4
житла.
million
Тому
Ukrainians do
це
not have any
найболючіша
housing
проблема сьогодні для
in
України.
this category of people.
І саме на це
Therefore, it is a big
спрямована
problem for Ukraine,
основна,
and we
основний запит
target
від
it,
ВПО, і відповідно державна
and
політика
IDPs need
спрямовується
this
саме на
kind of
закриття
support.
цих проблем.
So state policy is about
Щодо
covering
ефективного
these issues.
досвіду. Дуже
Speaking
позитивний
about
досвід
effective
отримала
expertise, we have
така
good
ініціатива щодо
experience when
створення
we
рад ВПО.
speak
Це
about the
консультативно
initiative of the
дорадчі
IDP
органи,
councils.
які
These are
протягом останніх 2 років
consultative
їх було створено
councils
750
that
одиниць при різних органах
were
і
created
державної
all over
влади, і
Ukraine.
місцевого
750,
самоврядування.
in fact, were created
Ці органи не тільки
under various
збираються для того, щоб
institutions, including
підсумувати і
local
узагальнити всю
administrations, so
проблематику
they do not
ВПО в
only
конкретному регіоні,
try to
а ще й
generalize
випрацьовують
the issues
рекомендації для
of
органів влади,
IDPs in a certain
які є
region, but they
обов'язковими
also
для
draft
розгляду. Ми
recommendations
розуміємо,
for
що
the
не
state
обов'язкові для
bodies
виконання, але
that
орган влади має розглянути ці рекомендації
must be
і
considered by the state
відзвітувати
bodies,
перед Радою
and
ВПО,
state
які
bodies have to
з цих
report to
рекомендації
the
прийнятні,
IDP
які
Council
можуть
as
бути
for
виконані, а
such
які,
consideration
на
of the
жаль, не можуть через
recommendations,
фінансові або будь-які інші
because
проблеми.
sometimes these recommendations
Також
cannot
позитивного
be
можу
actually implemented due
відмітити
to
активну роботу
financial
волонтерських
constraints.
організацій і громадських
And let me
ініціатив,
also
які
note
надають
the activities of the
гуманітарну і правову допомогу.
organizations
Міжнародна
of volunteer
спільнота після
activists
початку
and
повномасштабного
other
вторгнення
international
дуже активно
organizations,
долучилася до допомоги
starting from the
Україні,
beginning
але,
of
звичайно, їх кадрового складу не вистачило для того, щоб
full-scale invasion.
забезпечити,
The international
закрити всі проблеми в
community
Україні. І
worked a
тому
lot in Ukraine, but
вони
they didn't
залучили
have enough
партнерські
staff,
українські організації, які
so
дуже
they had
показали
to
свою
engage
ефективність.
Ukrainian partner organizations
Що
that
стосується
proved to
міжнародних
be extremely
організацій,
effective.
то Україна
Speaking
отримала
about
не лише
international
фінансову допомогу,
organizations,
а й
let me
консультативну
note they
допомогу,
provided not only
допомогу щодо
financial
обміну
support,
досвідом.
but
Тому для
also
нас той звіт, який ми
expertise.
сьогодні
They
чуємо,
provided
дуже
their
важливий
expertise,
для того,
and
щоб
this
Україна
report is
побачила
also
досвід
very
інших
important
країн.
for us, for
Можливо,
Ukraine, to see the
змогла
experience of
це
other
застосувати
countries,
при
for
допрацюванні
Ukraine to
власних
implement it
законодавчих актів для того, щоб покращити
in its
якість
own
надання послуг і
legislation,
захист
to
внутрішньопереміщених
improve the
осіб.
quality of the services for
Також
IDPs.
із позитивного можу назвати,
Besides,
що в
the
Україні
positive thing
створено
here is
великий
that in
координаційний штаб з
Ukraine,
питань ВПО.
a
І до
huge
цього долучені, до цього
coordination
штабу він збирається
headquarters
один раз на тиждень, і
were
до нього
launched,
долучені всі
and
міністерства, починаючи
it
з
has a
Міністерства
meeting
соціальної політики,
each week.
ті, хто
Ministry
займається
for Social
житлом, ті, хто
Policy
займається
and people responsible for housing,
розвитком інфраструктури, охорони
those
здоров'я,
responsible for
освіти.
the
Туди залучені
infrastructure,
всі
healthcare,
регіональні
education, are
військові
engaged in
адміністрації,
this
всі
coordination
ради ВПО.
headquarters, as
І
well
такий
as
штаб
the
збирається щотижня, і він налічує до 300 осіб.
IDPs
І
and
кожен може
military
поставити питання.
administrations. Up to
І це
300 people
питання, якщо воно
participate in
часто
each meeting.
повторюється,
Anybody
то
can ask
уряд
a
бере
question, and if
ці
the
кейси для
question
того,
is
щоб
reiterated multiple
вдосконалити
times,
національне
then the
законодавство.
government
І нам здається, що
takes
це дуже
the
важливо.
issue and
Що
works on the
стосується
national
викликів
legislation
або
to improve
те, з
it.
чим Україна
As for the
дуже
challenges,
погано справляється
what are
через
the challenges for
продовження
Ukraine
військових
here?
дій, через обмеженість
What's
фінансових
difficult for
ресурсів,
us?
економіка країни
First of
зруйнована,
all, it
і
is
тому
about
я назвала вже
the
вам цифру
ongoing
4,6 мільйонів
warfare.
ВПО.
The
З цієї
economy is
цифри
ruined
тільки
and
1,2
the budget is
мільйони
constrained. So let
отримують
me
фінансову
reiterate once
допомогу на
again.
проживання.
We have over 4
І ці
million
цифри дуже
IDPs, but only
маленькі.
2.5 of
Сьогодні
them
діти
receive
і люди з
social
інвалідністю отримують всього
support, and
$72 на місяць.
people with disabilities and
Всі
children
інші
receive only
ВПО
$72
отримують $48
per
на
month.
місяць. Це
Other
дуже маленька
IDPs receive
цифра, і
only
звичайно, що
$48
цих коштів
per
не
month.
вистачає на проживання,
It's not a
особливо
big
для людей
sum,
похилого
and of course
віку.
it isn't
І
enough
іноді люди
to
вимушені повертатися
sustain their
на
living,
окуповані території
and
або
quite
території,
often
де ведуться
people
активні
have to
бойові
come back
дії.
to the
Для
occupied
того хоча б
territories or
не
to
треба витрачати
territories where ongoing warfare is taking
родинні фінансові
place,
ресурси на
because
винаймання
there
житла.
they don't need to spend money on rent.
Україна єдина
Ukraine
країна в світі, яка під час ще
is the only
ведення
country
активних
in the
бойових
world
дій
that
почала
during the
виплачувати приважні
ongoing
репарації за
warfare
зруйноване або
started
пошкоджене житло.
to pay the
І це дуже
interim
класний
reparations for the
такий крок
damaged
держави,
housing.
відповідальність
It's a
держави,
great step by the
бо ВПО
state. It's
відчувають,
the
що країна про
showcase
них
of
дбає,
responsibility.
і вони
The
можуть
IDPs
отримати
can see that
компенсацію і придбати
the
власне
government
житло на
takes care
території, де
about
немає,
them, and
де
they can
більш-менш
receive
забезпечена безпека.
this compensation in order to buy
Ті, хто
housing
не
in the
можуть
safe
отримати таку
regions,
допомогу
rather
через
safe
різні причини.
regions.
Наприклад, це
Those who
зруйноване житло
cannot
знаходиться
receive
на
such assistance,
окупованій території,
for
Україна не має
example,
доступу, щоб
their
підтвердити або
housing
спростувати
is
факт
in
руйнань
the
такого
occupied
житла.
region, where we cannot prove whether
Вибачте, будь
their
ласка.
housing was actually ruined.
Таких людей в колективних центрах.
So such people,
Ем,
they actually live in the collective
Але все
centers,
одно весь час в
but
державі
let me
проходять
note
міграції
that
ВПО.
there
Ми
are
побачили,
internal
що за останні
migrations
9
of
місяців більше
IDPs inside the
930
country
тисяч
within the last 9
змінили
months.
регіон проживання. Люди шукають там, де
Hundreds of
краща
thousands
робота,
of
там,
IDPs
де дешевше
have switched
житло,
to
там
another
же, де вони
region.
можуть
They're
влаштувати
searching
дітей до
for
садочків і шкіл
regions with better
безкоштовно.
job opportunities, better
Тому ці
healthcare,
процеси
better education,
безкінечні, і держава має
where
орієнтуватися на
rent
основні
isn't
потреби.
that expensive. So these are the
Держава
ongoing processes,
запустила
and the government has to meet
таку
their needs.
програму
The
як
government has started a program which
зняття
is
потреб
called
ВПО. Тобто, як тільки ВПО приїжджає у будь-яку приймаючу
which is
громаду,
about
відразу
meeting the needs of
соціальний лінійний
IDPs. When
представник
IDP comes to a particular
знімає
community, their social
основні
worker
потреби,
meets
що
an
треба
IDP
цій
and
людині.
has to cover
І
basic
цей
needs
такий
of their family.
підхід
And it
вирішення
is a
проблем конкретної
case
родини. Мені здається, що це
of
дуже
meeting needs
такий
of a particular
вдалий
family.
досвід
I think it's a great
спілкування і захисту
experience
прав
of
ВПО.
communicating with people and protecting their rights.
Я, можливо, перебрала трішки час, але я дуже вдячна за те, що ви
So sorry if I took too
зацікавились
long, but
питанням
I'm
захисту
very
прав ВПО в
thankful
Україні, готова
that
відповісти на
you're
питання, якщо такі ще
interested
залишаться. Ну
in
і
the
наразі хочу
rights
дуже
of
подякувати
IDPs
за
in Ukraine.
це дослідження, бо
And
воно важливо,
I would like
важливе
to thank
для
you for
України.
this report because it is very crucial for Ukraine especially.
Thank you very much for that. That's very useful description of how the voices of IDPs in Ukraine have been formally included into the feedback mechanisms, and not just listening to IDPs, but indeed involving them in the development of policy and development of programs. So thank you very much for sharing that with us. And I would just encourage everyone online, if you have questions or comments, please don't hesitate to use the chat. We can respond to some things directly online, and maybe we'll come back to the panelists as we go forward. So I'd now like to give the floor to Ms. Natalia Ángel-Cabo, who is a justice of the Constitutional Court of Colombia. And so the global report that we're launching today highlights some of the groundbreaking work of the Constitutional Court of Colombia to uphold the rights of IDPs over the years. And so given that the role of the judicial actors is still quite limited in many countries when it comes to internal displacement, could you tell us about what led to the important role that your court has played in this area in Colombia, and how has it been useful? Over to you.
Thank you very much. I'm really pleased to have been invited and congratulate the UNHCR for launching this important report, not only for Colombia but for the world. The report addresses two important decisions of the Constitutional Court, and I want to give a brief explanation on those decision, which at the end will tell you how we end up at the court addressing and becoming, I think, the judiciary, a very active actor in the struggle to respond to forced displacement in Colombia. So in this brief presentation, what I want to do is to explain what ruling T025 of 2004 is of the Colombian court. Is a very important ruling of the Colombian court. And the lessons that we have monitoring that case, because this is a report about implementation, and we have really tried to make the biggest effort in pushing for implementation of this judgment. And then briefly, I was asked also to talk about a recent ruling that we had that is about forced displacement and climate change. And so that I will do that in these 10 minutes that I have, and hopefully answering to your question. So basically, in 2004, due to the massive and frequent violation of rights of the internally displaced population by the armed conflict in Colombia, this led the Constitutional Court to issue ruling T025. This is a landmark decision, as I mentioned, that declared that the situation of the persons in internal forced displacement in Colombia, it's an unconstitutional state of affairs. that requires structural and coordinated actions by various authorities. What unconstitutional state of affair is in Colombia is a declaration that the court makes when there is a massive and frequent violation of fundamental rights of a certain population. It originates in structural problems usually linked to authorities' failure to fulfill their legal and constitutional obligations. Also, when individual legal actions filed by individuals are not enough to solve the problem and to put an end to the violations of right, complex judicial remedies are required that involve various high-level authorities. So it is always the unconstitutional state of affairs is a very ambitious ruling, try to push authorities to respond to what we call is a humanitarian tragedy. So basically, this judgment based on the accumulation of different tutelas, which is a writ of protection of for the protection of fundamental rights, made different orders to the Colombian government, among other remedies, to strengthen the public policy, to provide budget for that public policy, to basically design a public policy that has clear who are responsible for doing what, and with enough budgetary means in order to respond to the internally displaced population. That was 20 years ago, but basically 15 years ago, the court decided to monitoring the implementation of the case, given the structural and complex nature of the remedies that were established in Judgment T025. And so from then, we basically implemented what is called the Special Monitoring Chamber for Ruling T024. And which is an interesting kind of experiment of the court monitoring its own judgment, and it does so by using several tools such as public hearings, meetings, and also judicial decisions, evaluating and formulating sometimes new orders, and exceptionally using contempt powers. The special monitoring chamber has been very useful, for example, in providing spaces for dialogue among different actors. In these spaces, different actors jointly identify problems of the public policies, the need of correcting these public policies. Also, it brings light to new problems and new challenges that the implementation of the policy is facing. It brings together civil society, especially the persons in forced displacement, and authorities to talk about the implementation of the case. It also, and has been very, very useful, the special chamber has built a set of indicators that are based on what we call the effective enjoyment of rights. And they were designed to evaluate the progress of law and the public policy in the guarantees of the internally displaced population, and they serve two functions. They allow civil society and the authorities themselves to evaluate the impact and effectiveness of the policies and regulations in order to correct and improve them as necessary. I think that the special monitoring chamber, and I think the report addressed that, stands as an innovative accountability mechanism with a track record of significant impact. For instance, thanks to the chamber overseeing of the ruling, the contentious debate surrounding internally displaced persons figure prevalent in the early 2000s and have largely subsisted. For example, before that year, forced displacement in Colombia, even it was a very grave violation of rights, it was not in the public agenda. So I think we have contributed to keep the topic in place as a priority for governments. It also has helped to increase the budgetary allocation for addressing internal displacement needs. And also, I think it has fostered crucial dialogue and interaction between victims, authorities, as well as among national, regional, and municipal level authorities. Of course, it has faced several challenges as well, and I can address that at the end of this presentation. Another ruling that I want to address, which is important for the Constitutional Court, is a recent one, which is ruling 123 of 2024, is a very recent one. In this second case, which I had the honor of serving as a rapporteur, the court examined the tutela action brought by two elderly farmers displaced due to ongoing flooding caused by the Bojava River. The severity of the La Niña phenomenon made it impossible for residents near the river to remain on their properties, but the plaintiffs sought assistance from the Colombian Victims Unity, which is specifically designed to help those displaced by armed conflict. However, since this unit only supports victims of violence, the request for assistance was denied. Consequently, the case reached the Constitutional Court, which granted protection and ordered the municipality to relocate and assist the plaintiffs. Notably, this judgment extends beyond the plaintiffs, providing intercommunist effects to protect all similarly situated individuals. When this case arrived at my office, I immediately recognized it is a significant opportunity to elevate an urgent issue. While forced displacement due to armed conflict has long been a critical topic in Colombian constitutionalism, climate change displacement had not yet been addressed. To my surprise, this case stands also as among one of the first globally to tackle the issue comprehensively. So this case is important for several reasons. First, it recognized the category of environmental displacement. The ruling formally acknowledged at the national level the category of displacement due to environmental factors, including natural disaster, gradual environment degradation, and climate change. It identifies a deficit of protection. The ruling illustrates a gap in constitutional protection for individuals displaced by environmental factors, particularly those related to climate change. Third, it integrates international standards. The judgment incorporates international norms and experiences, reminding the states of its committing and offer guidance on preventing and responsive measures. Fourth, it acknowledged the complexity of the problem. And finally, it calls for legislative action. So I think this judgment is also crucial not only for its diagnosis value, but also for revitalizing congressional efforts. Nonetheless, we must acknowledge the complexities that arise from recognizing a reality that exists not only in Colombia, but in the world, and it's expected to worsen. Colombia already hosts 9 million individuals in forced displacement due to violence, whom the state has pledged to support. This case has raised valid concerns among officials about creating expectations among millions that the state may struggle to meet. Therefore, developing public policy on climate displacement necessitates a multidisciplinary approach incorporating diverse perspectives and voices to ensure that actions are feasible and avoid overpromising. So as you can see, the Colombian court has taken seriously, very seriously, the role of trying to promote rights and for the internally displaced in Colombia, and to make sure that really that are really guaranteed on the ground. Of course, we can help a broad debate in the country. We to for authorities on how to act. We can draw attention of the legislative vulnerable populations, but we do need other actors and support structures to keep pushing for these judgments to be implemented on the ground. At least for us, we are flexible enough to try to experiment as for a chamber in order to push for these judgments to be implemented on the ground. And so far, I think with all its limitations, it has been an important experience. Okay.
Thank you so much for your very interesting remarks on how the judiciary has played an important role in pushing forward the rights of IDPs in Colombia, and also, as you were just mentioning, in terms of the last judgment on pushing forward the doctrine around internal displacement, and which I think globally is indeed very relevant. So I would like to, our final speaker, and we are not having a lot of time for discussion at the end, but I would like to now pass to the final speaker, who is Ms. Maimouna Mbow Fam, the World Bank Practice Manager for the Fragility, Conflict and Violence Group. So Maimouna, how does the law and policy and institutional environment in a country support and facilitate development engagement to advance prevention, protection, and solutions for IDPs? And what are the key factors that can determine success or failure in this area? Maimouna, over to you.
Thank you, Elizabeth. First, I would like, do you hear me well? I would like to thank the organizers for bringing us together for this important discussion. Before joining the FCV group, I was country manager in Burkina Faso, where over 2 million people, around 10% of the population, have been displaced due to the rapid deterioration of the security situation and the growing presence of non-state armed groups. As this crisis unfolded during my time there, it became clear that internal displacement is not just a short-term humanitarian challenge, it's a development issue that need longer-term, that demands longer-term thinking and actions. The government was mainly focused on addressing the security challenges with just one option on their side was to create conditions for IDPs to return back home. Alongside with UNHCR, we're supporting the government in adopting a national strategy for the recovery of IDPs that including alternative solutions, including creating conditions in the host areas to allow IDP to stay and live with host communities. Because we heard from IDPs that if they have better living conditions where they were staying, they were willing to stay there. So the plan was to have a decent and cohesive manner, using decent and cohesive manner to support them to live with host communities. The World Bank development approach complements UN humanitarian effort by addressing both immediate needs and the root causes of displacement. These works require government leadership, institutional strengthening, and policy reforms. Political economic considerations are also critical in shaping effective responses because sometimes these issues also may be sensitive. As of January 2025, the World Bank Group has been actively engaged in displacement settings, with over 54 currently active projects across different regions supporting conflict-affected communities, including IDPs. This project provides just over $10 billion in financing to enhance access to jobs, to deliver basic services and economic opportunities for both host communities and IDPs. In many countries, we have seen that investing in social protection, urban development, infrastructure, and connectivity, including social cohesion and resilience building, does not just support IDPs, but it strengthens the entire communities and address drivers of fragility and reinforce the social contract between the government and citizens. So what are the key factors that can determine success or failure in this area? A short answer is an effective implementation of the legal and institutional framework is a key factor of success. And a huge implementation gap is a high risk of failure. As highlighted by the speakers today, law and policies action are the solid foundations needed to address solutions for IDPs. However, lessons learned from different countries evidence a gap between the books, de jure, and the practice de facto. Many countries have good laws and policies, but not fully implemented to achieve expected outcomes for IDP. So an effective implementation requires one, strong government leadership and institutional capacity, including at the local level with local authorities. Two, inclusive financing that takes into consideration the needs of IDPs and also host communities in conflict-affected areas. Third, data that inform policy and decision-making. And four, monitoring and accountability mechanism to track progress. The government leadership plays a pivotal role in addressing internal displacement, particularly through the development of IDP inclusive and IDP specific laws and policies. Effective implementation also ensures a strong coordination across ministries, local authorities, and partners as displacement affects critical areas such as housing, employment, health, education, social protection. So a holistic approach led by the government is essential to ensuring comprehensive, sustainable solutions that meet the need of internal displaced persons. For instance, in Ethiopia, the World Bank supports the government of Ethiopia in implementing the law enacted by the House of the People Representatives in 2023 to enhance the inclusion of vulnerable groups, including IDP, and the digital identification project called ID4D project, financed by the World Bank, while other actors, including the United Nations Economic Commission for Africa, provide technical assistance. The federal government's leadership and the coordination have helped to mobilize contribution across ministerial departments and support from various partners. The second key factor of success is an adequate financing that aligns with the identified priorities for IDPs and conflict-affected communities. Development assistance has been effectively used to advance agenda in ways that stress shared benefits and allow government to lead a national response with long-term financing. Some partners need to continue to be further committed to support the integration of IDPs in country, development programming, including by ensuring that IDPs are addressed uniformly across the government planning and sectoral strategic instrument. This approach would facilitate the inclusion of IDPs in the country partnership framework, which is out strategic document to engage with each government, and it's also help to recalibrate our intervention through analytics to have better knowledge of what needs to be done, policy actions, and investment to include IDPs. So, however, reliable data, particularly data that governments own and trust, such as the official statistic, remain a key challenge. Data is also necessary to track progress toward durable solutions to internal displacement. To that effect, the World Bank, in partnership with UNHCR, has established a joint data center to support better quality data for evidence-based programming on internal displacement. For instance, the GDC is currently supporting some survey to include IDP in the harmonized household budget and living condition survey. The data and evidence coming out of these activities have helped countries across access development financing and inform the design of development program for IDPs in Colombia, Yemen, Iraq, Chad, to name a few. Moving forward, the World Bank and UNHCR through the GDC will continue to capitalize and sustain these gains to support durable solutions for IDPs. And as the saying goes, what get measured, get managed. Tracking progress is key to ensuring that policies translate into real world impact. The World Bank Corporate Scorecard now tracks support providing to IDPs and host communities, focusing on policy improvement, service delivery, and economic opportunities. This is a major step, and it helps consolidate lessons learned, measure impact, and refine approaches on real-world feedback. I know we are running out of time, but I have just two more points to conclude. One is adaptability is essential. Displacement situation evolve, and policies must remain flexible to respond to new challenges and opportunities. So it's good to have some flexibility and maybe have more policies than law, and also prevention. The World Bank FCV strategy places a firm focus on developmental response to prevent conflict and interpersonal violence, recognizing their role in driving displacement. So just to conclude, given this constraint of time, I would like to reinforce the need to turn policy into actions, and the effectiveness of displacement policies isn't only measures by what's written in legal framework, it's about how well they are implemented and whether they're creating lasting impact on IDPs or not. Over to you, Elizabeth.
Thank you very much, Maimouna, and I think you covered quite a number of important questions about data informing policy, about the financing models. There was a question in the chat about what do we do now with a crisis in humanitarian funding. So I think that remains essential, but it is also a longer term development financing issue in many countries, which needs to be addressed. And then maybe just to say that the social cohesion component that policy should not only address IDPs, but also the communities where they are hosted as well. So, dear participants in this event, I'm afraid we don't have time. Some of the answers were given directly to colleagues in the chat. We don't have time for a discussion, but I would like to thank everyone for participating and give the last word to to Paula to wrap up some of our discussions and give us her final thoughts. Over to you, Paula.
Thank you, Elizabeth. And I would like to acknowledge and appreciate the interventions by Olga, Natalia, and Maimouna. They were very important interventions. Your insights have highlighted the critical roles of the ombudspersons, the courts, the development finance organizations, and others in strengthening government functions for prevention, for protection, for solutions. So thank you for today, and thank you for your work. It is clear that no single government institution, despite its willingness, can manage alone. I think that's a big takeaway from this report and the conversations. We also know that IDP organizations, NGOs, and international organizations play an important role in supporting governments to fulfill their obligations for IDP protection. This financial crisis underscores the necessity, more than ever, to work together. And finally, the importance of learning from each other cannot be overstated. The report demonstrates, for me, a glass half full perspective, acknowledging significant progress throughout the years, while also highlighting the need for continued efforts. The report gives hope. For me, this report gives hope, showing that while much has been achieved, much more remains to be done. I look forward to working with all of you to improving implementation for law and policies on internal displacement. And yes, critical crises like the Sudan crisis, Myanmar crisis, Haiti crisis, the process that follows with Gaza are completely valuable for us, and we are working to support them and highlight them. Thank you very much for this important conversation today. Thank you, Elizabeth.
Thank you very much, Paula, and thanks to all the participants and all the presenters. Thank you to you also, David, for presenting the report. Have a good afternoon, good morning, good day to you all. Bye-bye.